Judith, I saw the SG. I don't know why she's hiding. The SG is here, and from the Attorney General's chambers, also from the Ministry of Justice, the Legal Reform Department is also here, and also from Parliament. And we also welcome...
Chairman, if you just allow me, Marlene Aldred, Mrs. Masado is also here from the Attorney General's chambers.
Well, hi, Ms. Masado. Nice having you. Just to indicate that members, that we have three presentations this morning, and we're likely to take them in the order of UNICEF, JB, and then DPP. Okay? I don't think they're lengthy presentation. Depends on your questioning. Also to indicate that Jamaicans for Justice, the Jamaica Youth Advocacy Network, and Children Watch Legal also made their submission, came in between yesterday and today. But we won't take them today, we take them at another time. The Jamaica Psychiatric Association is seeking a 6 weeks extension. I don't think so. We can't give them 6 weeks. We'll respond to them and ask them to please let us have it in another couple of weeks.
Chairman, to relate that I no longer hold the post of president of the association, so that decision was actually done in my absence here.
No, well, I understand.
Thank you. But I will convey to them.
Yes, I don't think we can give them more than 2 or 3 weeks at most. And hopefully we can get a submission, and then all those submissions we can then just take at a later date. But I'm very happy that today we are able to have 3 presentations, which we will take very shortly. The matter before us is the minutes. I don't know if members had the opportunity to read the minutes and to indicate, are there any corrections that... most of it, as you will recall, were just housekeeping matters. And then I did make a statement which a fair amount of it was carried. But if there are no corrections, can I ask for a motion for confirmation? Thank you, Senator Brown. Very well. Okay, any matters arising that you would raise before the presentation begins? If not, we can then ask the presentation to begin. All right. Thank you, members. Ambassador, UNICEF, we're going to ask you to make your presentation now. I think we don't need to really name the members of the committees. Other members are coming in one by one. But just indicate who is with you, and then you can begin. Thank you.
Thank you so much, Mr. Chairman. Good morning, honorable members of the committee, distinguished guests, ladies and gentlemen, good morning. Let me start by thanking the Joint Select Committee for inviting UNICEF to share its consideration on the proposed amendment to the Child Care and Protection Act 2004 and related laws. We welcome the opportunity and reiterate our entire disposition to keep cooperating with Jamaica's authorities in the effort to promote universal respect for and observance of children's rights and freedoms. UNICEF is deeply concerned that the proposed amendment to Child Care and Protection Act would require children convicted of murder to serve a mandatory sentence of 20 years in prison before becoming eligible for parole. UNICEF, too, is concerned about, and I open a quotation here, the uncontrolled and unabated murder rate that ranks highest among 22 Latin American and Caribbean countries, close quotation, as mentioned in the memorandum of the object and reasons for the cited amendment. UNICEF agrees as well with the fact that homicide must imply serious consequences for the person found guilty. However, and I want to be emphatic on this seriousness of these consequences has to be measured in relation to the effectiveness in preventing recidivism and in decreasing the murder rate in a sustainable way, which I think is our common goal. The way to reach this goal is what UNICEF wants to invite Jamaica to review together in order to achieve a safe and secure nation while respecting children's rights. The evidence and knowledge accumulated by UNICEF allow us to affirm that the imposition of long periods of imprisonment for children does not contribute effectively to decreasing the rate of crime, nor does it help to deter offending by children. To develop this argument and offer alternative, the effectiveness of which has been proved, UNICEF has brought to Jamaica Dr. Shelley Casey, an international child justice specialist with over 20 years of experience supporting child protection reforms and access to justice for children. In particular, she has extensive experience drafting child justice law and strategies, supporting national justice reforms, and training justice sector professionals. The portfolio of her work covers more than 25 countries in different regions, including Latin America and the Caribbean. Dr. Casey, let me pass the floor to you, while urging the honorable members of the committee to bestow much consideration upon our concerns today.
Just for the writers, the stenographers, could you just introduce yourself before you begin, okay? Your name. Yeah.
Good morning, honorable members. My name is Shelley Casey, a child justice specialist with UNICEF. I'd like to focus my comments this morning on three key concerns that UNICEF has in relation to the imposition of a mandatory non-parole provision specifically on children. And in particular that this approach would be contrary to Jamaica's obligations under the Convention on the Rights of the Child, and not in conformity with the spirit of the Child Care and Protection Act itself. Based on the international evidence, it will likely not contribute to public safety, which I think is the ultimate aim of the amendment, and also that it's counter to a very large, well-established global evidence base in terms of how to effectively address offending by children, in particular violent offending by children. The UN Committee on the Rights of the Child has been clear that imposing mandatory minimum sentences on children is incompatible with the core CRC principles of proportionality and use of imprisonment as a last resort for the shortest appropriate period. And instead, it strongly urges that countries take a much more nuanced and discretionary approach when handling cases involving children. So rather than sort of inflexible mandatory minimums, judges should be given discretion to exercise their authority based on an individualized assessment of a child's unique circumstances. And that includes, for example, taking into account that individual child's level of cognitive development, their ability to understand the consequences of their actions, the child's background and circumstances, the extent to which, for example, they've been influenced or induced by adults or others into that criminal act, and also that individual child's rehabilitative potential and the prospects for ensuring that that young person becomes a constructive member of society through positive interventions. These principles are very well reflected already in the Child Care and Protection Act, which does encourage judicial discretion and the use of social inquiry reports to have a holistic picture of a child before the court imposes a sentence. That's not to say, of course, when a child's committing a serious crime like murder, of course, the court needs to consider public safety and needs to impose serious consequences on that child to reflect the gravity of their actions. But the UN committee has been clear that in doing that, still the long-term aim is that child's rehabilitation. It's supporting that child to assume a constructive role in society rather than pushing them further into a life of crime. Another key point we know from the international evidence is that, in fact, harsh sentences don't deter children from committing crimes. The principle of deterrence is based on the assumption that a rationally thinking person will weigh the potential consequences of a criminal act and be deterred because they're thinking through, the risks and what will happen to them if they do commit that act. But the international evidence tells us that, in fact, children, really quite frankly, up into their mid-20s, lack sufficient brain development to think rationally that way. Our slide is not tremendously clear, but you'll see from the photo, or the diagram on the right, shows MRI scans of brain development, starting from early years up into the mid-20s. And the box, the part of the brain shown in the box, it's what's referred to as the prefrontal cortex of the brain. That part of the brain is actually the last to develop. And that's the part of the brain responsible for all of our higher functionings associated with criminal culpability. So things like understanding consequences of your actions, thinking rationally, controlling impulses, good decision making. All of that is controlled by the prefrontal cortex, which is not fully developed until a person is well into their mid to early 20s. Most studies are saying probably around about 25 before a person is fully capable in that area. So this is why we see teenagers in particular engaging in risky behavior, being influenced by peer pressure, being influenced by being quite susceptible to influence from adults to engage in criminal behavior, and not thinking before they act. It's because their brains are not there yet. So just knowing that, there's putting a harsh penalty out there is not likely to have an impact on young people because they don't stop and think rationally before they act. That deterrent element just simply doesn't have a strong impact on children. And I think we can see that in terms of the strategies that Jamaica has used to date to try to crack down on youth crime, and particularly violent youth crime. As the Court of Appeal noted in the Morrison case, Jamaica already has quite a harsh sanctioning framework for children who commit the more serious offenses. And that approach has not really been very effective, having that harsh sanction on the books already. So rather than doubling down and making the sanctions even harder, I think now's the time to step back and think at other strategies, other approaches that will better deter youth crime. Because we know there's no evidence globally that harsh sanctions prevent or reduce youth crime. There's now quite a large global body of evidence in terms of approaches that do work. And key to that is understanding the risk factors behind juvenile offending. There's surprisingly consistent evidence globally that shows there's sort of a core set of risk factors that put children at higher risk of engaging in criminal activity. And that includes things, for example, like history of abuse and neglect in their homes, family dysfunction or poor parenting, lack of pro-social role models, growing up in communities that are blighted by crime and criminal activity and gang activity, associating with negative peers, children who are performing poorly in school, or who are excluded from school. All of these factors put young people at significantly greater risk of engaging in criminal activity or being lured into that gang culture and criminality. Associated with this, of course, are some positive or protective resilience factors in each of these domains as well. what the large body of evidence tells us, and you'll see some of those key studies in the endnotes of UNICEF's submission, is that the most effective way to address youth offending, including violent youth offending, is to identify and address the child's individual risk factors. So it's understanding what's gone wrong in that child's life to lead them to where they are, and providing a package of rehabilitative and therapeutic interventions that address that child's specific risk factors. And there are a number of studies that show that public safety is, in fact, better served by supporting children to become productive and law-abiding citizens through appropriate interventions, rather than just harsh punitive penalties. Now, in case of children committing various serious crimes involving violence, and particularly murder, that rehabilitative process might begin in an institutional setting. But the key is to ensure that the interventions are tailored to that individual child's risks and needs, and that we allow scope for the fact that children can be rehabilitated and returned safely to society when provided with the appropriate support and intervention. Drawing on from that point, we also have quite a strong body of international evidence to show that children have a stronger rehabilitative potential than adults, children who are committing crimes. And that's partly because of their young age and the fact that they're still in the process of developing. So they tend to respond more quickly and more effectively to rehabilitative interventions than a hardened adult criminal would. And UNICEF is certainly strongly of the opinion that no child, even children who commit serious violent crimes, is beyond rehabilitation. And we need to afford the opportunity for that young person to turn their lives around and return to society as a law-abiding and productive citizen. So because of that, international standards emphasize that decisions about a child's release or parole from imprisonment shouldn't be based just on number of years, a random number of years served, but should actually be determined by an individualized assessment of the rehabilitative progress that young person has made and the extent to which they still pose a risk to society. And I know in recent years, Department of Correctional Services has made quite a bit of progress in terms of strengthening the services available to children in juvenile correctional centers, in terms of conducting an individualized assessment on intake, having a plan for that child's rehabilitation and reintegration while they're in prison, and then planning as well for the release and reintegration back into the community when they're ready. Investing in that approach, investing in those interventions would be much more effective in terms of promoting long-term safety than simply having a harsh mandatory minimum imposed on children. And in fact, a lot of the progress that a child might make in the juvenile correctional center will likely be lost if they get transferred to an adult correctional center at the age of 18 and then have another 10, 12, or 15 years to serve. I mean, I think it's very hard for a young person to stay committed to their rehabilitation and that aim, of going back to their families and communities if they're looking at a 20-year time frame, which is a very long time for a young person. Another key lesson we learned from the international evidence base is that imprisonment actually increases the likelihood of reoffending and ultimately puts the community at greater risk. There's now a very large body of international evidence showing that imprisonment of children is counterproductive because it in fact increases the chances that that young person, once they're released from custody, will go on to reoffend. And the longer a child spends in prison, the greater the chances that you're creating a lifetime criminal. So really, any perceived punishment or deterrent effect, value of the mandatory imprisonment terms is far outweighed by its detrimental impacts, both on the individual child and also on public safety. There are a number of documented reasons why imprisonment of children fails. Juvenile correction centers are often referred to globally as schools of criminality. Yeah? If you imagine you take a young person from the ages of 13 or 14 and place them in a correctional center during these very formative years of their life. So their only friends for the next 20 years are going to be criminals. They're removed from positive influences of peers, of their family, and those positive milestones in people's lives that put them on the right track. They're not going to have a job, they're not going to get married, they're not going to have children, they're not going to settle into a normal adult life. Instead, you're further inculcating them into a criminal and gang culture. Because they're growing up and spending their formative years in a very harsh correctional environment. And no matter how good a juvenile correction center is, it's still a very harsh environment for a young person to be raised in. They're typically exposed to violence and abuse, either directed at them or at least witnessing it. And the skills they're learning to survive in a correctional center are very different from the skills that we want them to have going back out into the community. So by the time that person is released, that 13 or 14-year-old is released, when they're 33 or they're 34, they're now a seasoned criminal. Their only friends are criminals. They're further inculcated into a gang culture, and they don't have any pro-social and positive skills for going back to society and assuming a constructive role. That's not to say, of course, imprisonment is never necessary. Sometimes when children are committing serious crimes involving violence, a custodial period is necessary for public safety. But it's why the international standards emphasize for the shortest appropriate period. Imprisonment's needed for the time, for a period of time, is sometimes needed for a period of time for a child to get intensive support and supervision, but we want to minimize it as much as possible because the longer that child is there, the more they're inculcated into a life of crime. Now, although this can be difficult for legislators because when young people are committing serious crimes involving violence, particularly murder, there is an understandable public reaction to that and an understandable clamor for harsher sanctions on those young people. But what we know is from the evidence is that what the public wants is not actually what works, and it's not likely to lead to long-term public safety. So we need to look at strategies that will help tackle the root causes of offending by young people and work with individual offenders to support them towards a pro-social life and to become constructive citizens. Here in Jamaica, crime by young people is being driven by a complex range of social and economic factors. We've got relatively high levels of child abuse and neglect, children experiencing trauma, growing up in communities with significant violence and gang activity, challenges in terms of educational achievement and educational exclusion, socioeconomic disadvantage, and sometimes significant mental health issues. And current social services are, I would say, under-resourced to be able to fully take on those challenges. There are also deeper structural and historical factors that create contexts where violence in some communities is legitimized and where criminal gangs are recruiting and exploiting vulnerable young people. So tackling these root causes of crime is a far more effective way to address society's concerns and the reputational concerns for the government of Jamaica, rather than simply reacting after the fact and imposing harsh punishments on individual child offenders. we need to get the root of why children have ended up where they are, rather than just reacting, looking at the causes rather than just reacting to the symptoms. So UNICEF therefore calls on greater investment in addressing those underlying causes of crime, including addressing the socioeconomic factors that are driving crime in communities, supporting children and families, and ensuring that every child has access to quality education, to healthcare, and to social protection. UNICEF therefore calls on the government to reconsider the proposed mandatory minimum sentence for children convicted of murder. And we encourage instead to maintain the current position under the Child Care and Protection Act, which is giving judges discretion to consider the individual child and the circumstances, and to determine a sentence that's most appropriate for that individual child's rehabilitation, and to ensure public safety. We'd also call on the government to continue to invest in a strong and differentiated child justice system, taking into account international standards and best practices, with a focus on evidence-based violence prevention, restorative justice, and rehabilitation programs. And then finally, to invest in services for children and their families in order to address the root causes of crime. Thank you.
Thank you very much, Ms. Casey, and also before you, Country Representative Ms. Isisa. Before I ask members to ask a few questions, let me also welcome other member, Minister Favour Williams, and also the Children's Advocate who is here with us, Mrs. Diana Gordon Harrison. DPP is here with us and her team, and we'll come to you shortly, and the President of the JBA. Just taking Chairman's privilege and ask, you are against the 20 years minimum mandatory. I see all the proposals in terms of dealing with children. What would you propose as the appropriate figure? 10, 15, or less? Since you disagree with the 20, what would be I think from your presentation, you do agree that at least rehabilitation may well, for serious crimes, have to start in an institution. So what would you recommend instead of 20 as the appropriate minimum mandatories? Secondly, we can't ignore, Ms. Casey, that Jamaica in particular has a serious problems, not necessarily with young children, but with teenagers, 15, 16, 17. They are really, in the Jamaican context, are responsible for many, many serious crimes. And I think, these are the persons who we wonder what can be done with them. Because in many ways, they are now hardened criminals in many communities and are being used by gangs to carry out really serious crimes. And so the question is, we can make a differentiation between children under 15 or 15 and under and say they definitely can be rehabilitated in good time. But when you take the 16, 17-year-old, most of whom have left school by then, do you have any distinction? I mean, what could we do with those in particular? So those two observations.
Thank you, Honourable Chair. With respect to your first question, in line with international standards and best practices, the approach in terms of mandatory minimum is to have none. That in fact, the approach to sentencing children should be discretionary. The UN Committee on the Rights of the Child and the UN Committee on Torture have both said even life imprisonment when imposed on children is cruel and inhumane punishment, that judges should be given discretion to determine on a case-by-case basis what the most appropriate sentence is for that individual child. So that means not necessarily setting a mandatory minimum, but relying, as we always have in common law in jurisdictions, on judges' good discretion to make appropriate decisions on a case-by-case basis. That allows a greater differentiation between a 12-year-old, a 13-year-old, and an 18-year-old, depending on their individual development, the risk factors, their rehabilitative potential, and the specific circumstances of that crime. There are too many variables to stipulate in law what the appropriate punishment is for every single child, regardless of the circumstances.
Colleagues?
I support you when you talk about investing in ensuring that our children are not abused and neglected and so on. But we're talking about a child who would have committed murder, would have killed someone, and is before the court, would have gotten the sentence, and we're simply talking about how many years this child should serve before being considered for parole. Murder is a serious crime. So it's not as if we're putting children in jail who haven't done anything. Child has committed a very serious crime. And you're saying, let's assess, let's intervene, yes, but where should that child be while this is happening? Should that child be in society while this is happening? This assessment is happening? Or should that child be in an institution and is also paying for the murder that was committed? We're not talking about children who are innocent. We're talking about children who commit the gravest of crime, that of killing someone else.
UNICEF recognizes, of course, that taking a life is the most serious act that a person can commit. And there's no question that in most countries would attract some period of imprisonment. The question is simply, do we try through statute to determine for all children at all times how long that period of imprisonment needs to be? Or do we allow flexibility for the individual circumstances of that child, their young age, the extent to which they were influenced or induced by others, and their rehabilitative potential? And that rehabilitative journey most often does need to begin in an institution, in a correctional center. But at some point, if that child responds appropriately, at some point they become safe to return to the community. And in fact, returning them sooner rather than later makes it more likely that they're going to reintegrate successfully and break from their criminal past. Although these children have committed heinous acts, there are successful programs globally that will assist young people to rehabilitate and to return to the community constructively. We've got things like cognitive behavioral therapy, multisystemic therapy, family functioning therapy, which are used in the US with very hardened gang-involved young people, and have been proven we can turn these young lives around. So rather than writing them off as hardened criminals who should be warehoused for 20 years plus, We need to leave scope for the possibility that these young people can be turned around, and that there are, with proper investments, programs and services that can assist them.
Thank you, Chair. You said that if a child is institutionalized in the way that we're talking about at 14 and emerges at 34 to get back into society, you really have you're sending back a hardened criminal into the society. The minister asked you, at what stage would you think whether should you have a differential system? So under 15 is one sentence, one mandatory, because whereas for another category you have another sentence. Is there any analysis which has been done to show the average time within which a person will cross from being able to be rehabilitated to becoming a hardened criminal? And do you have any data that shows the impact of different range of sentencing on a child? That is to say, for example, if in a jurisdiction where you have mandatory sentencing, is it possible to evaluate the results of that? Is it possible to evaluate the results of, say, a sentence of 5 years as opposed to a sentence of 10 years, so that we can analyze the impact of a range of sentencing? And finally, do you believe that as heinous as a crime of murder is, because that is what we're talking about now, do you believe that nonetheless, although there might not be a direct defense such as self-defense, which would of course be exculpatory, do you believe that there might be circumstances under which that murder has been committed which would rise to a level where, although a sentence needs to be imposed, a sentence of imprisonment needs to be imposed, a signal to the rest of the society how that act is viewed? A court could find the appropriate sentence in which all of the factors could be satisfied. And I know I'm speaking in a very circumlocucious way, so let me come to the last one. So you have to punish a child. We agree, you said that. There are some circumstances where a child has to be punished, and punished by imprisonment. Minister has said that it is, we must take into account the fact that this is murder, the ultimate act which you could ever commit. I am asking, in spite of the fact that a life has been taken and there are no absolute defenses available to the child, do you think there are other circumstances which could minimize the damning effect of the fact that it's a murder, a life that has been taken?
So in terms of your comment about the average time, again, there is no concrete time where you can say a child at this age needs to spend this much time in prison before they're rehabilitated, because it really does depend on that individual child, their unique risk factors and resiliencies, and why they ended up at the point in their life where they are. Just by global comparison, most countries do in their legislation set a maximum term of imprisonment for juveniles who've committed serious crimes like murder or life or capital offenses. The most common globally, it does range, is 10 years. So in many countries, we wouldn't even be talking of a sentence beyond 10 years for a child who committed murder. Within that, there are a range of circumstances that might have led a child to where they are, and a range of different forms that a murder might take. Taking a life is always heinous, but for example, you may have a 14 or a 15-year-old who watched his mother being brutalized by his father for years, and finally, you know, one evening decides that he's going to eliminate the risk to his mother and kill his father. Now that's a heinous act of killing your own parent, but there are circumstances behind that that would suggest that young person with support can be rehabilitated and wouldn't necessarily be an ongoing risk to the community. So that there are multiple variables in terms of what leads a young person to be where they are and what the circumstances of that individual murder might have been, which all influence the decision that a judge should make in terms of how to balance the need to address public concerns and public safety, but also not throwing away that young person and recognizing they can still become a productive member of society with the appropriate support. But it's not something that can be easily quantified. We do have studies that show, for example, and you'll see in the submissions that show for every day a juvenile spends in a juvenile correction center, for a felony offense, you're increasing the risk of reoffending by 1%.
As a follow-up question, Minister, part of what plagues us here in Jamaica is the gun violence and the gang violence, which from the narratives are committed by very young persons. You know, 16-year-olds, 12-year-olds, and so on are involved in that sort of situation. Do you believe, then, that a differentiation ought to be made for young children who are involved in that type of activity, who are involved in gang warfare, who have reached a stage where, as a perpetrator, they are so embedded in that kind of culture that they might not be as open to rehabilitation as, say, the case that you outlined? Do you think there should be differentiation between that kind of person as opposed to the kind of person who you referred to, who has witnessed this abuse and decides that he has had enough of it?
Again, I think it comes down to that individualized approach, looking at that child's unique needs. What the brain development research shows us is that well into their early 20s, children's brains are still developing. They are more open than an adult to rehabilitation. So it isn't that they're hardwired and hardened into crime by the age of 18 and cannot possibly be changed. Every child has that potential. Every child and young person has that potential for rehabilitation. The level and intensity of support needed varies between those two circumstances. So a child who's 12, 13, 14 and reacts to a situation of family violence, as I mentioned, might need a shorter term of imprisonment and less intensive rehabilitative support. A child who's already well inculcated into gang culture and violence will need much more intensive support and intervention. But that doesn't mean that they're a lost cause and can't be turned around.
Part of your evaluation, have you looked at the facilities in which children are incarcerated in Jamaica?
Yes, I've previously been doing some work as part of a team supporting Department of Correctional Services to strengthen behavior management policies and practices and therapeutic-based approaches in the at least in the juvenile correctional centers.
Do you think that the circumstances, the conditions are conducive to rehabilitation? Mm-hmm. I'm asking you frankly because mm-hmm. I don't know. So, mm-hmm. So are they conducive? Can they assist in rehabilitating a child? Mm-hmm.
I think we have the Indicom report from 2020, which did flag some significant concerns about the conditions and treatment of children in juvenile correctional centers. But the Department of Correctional Services has really taken that report on board and has been making progress in recent years in terms of strengthening their programs and services for inmates in those centers. So there is still a lot of progress a lot of scope for improvement, but progress is being made. And in particular, since the Diversion Act of 2018, there's been a focus on individualized assessments. As children come in, they do an individualized assessment of them. Each child has their own plan for the rehabilitation, and they're working at improving staff capacity to provide trauma-informed care, to be working with young people to address their risk factors. So that I would say progress has been made. There is still room for improvement, but investing more in those services, providing that good, solid rehabilitative support while children are in the juvenile correctional centers, and then providing them the hope of release and a pathway out, with, again, continued support once they return to the community, so that you're working intensively with them and their families to divert them away from that gang culture, to address the problems they had before they went in and put them on a better path.
Senator Binns, yes.
Thank you, Mr. Chairman. I just want to follow up from Senator Scott Motley's question. As we're talking about rehabilitation, as you are aware, the Child Care and Protection Act provides that if you're over the age of 14 and you're sentenced, whether you're found guilty for murder, then you can be housed in any facility, including an adult correctional center. In light of what you're talking about, the influences and children becoming hardened criminal when they leave these institutions, I wonder whether there is any, well, I want to get your thoughts. For example, in a situation, if we were to, at the end of the discussion, agree to a perhaps phased sentencing for children, or perhaps leave it as it is for the court to make the determination, whether it would not, in giving support to your argument of rehabilitation, be a recommendation, but I'm putting it to you, that there is a separate holding area, a separate entity, a separate institution for these children who are between the age of 14 and 18 years old, and have been found guilty, to be in legal custody rather than being housed in custody with the adults.
Yes, I think under the current Child Care and Protection Act, I think judges have all of the tools they need at their disposal to deal with these cases appropriately. They have the capacity to impose life imprisonment, and they have the capacity to determine an appropriate parole and eligibility period. I think those tools are strong enough for them to respond on a case-by-case basis and determine the most appropriate sentence for an individual child without the need for further amendments. In terms of placement of children, globally we know one of the worst things you can do for a young person is put them in an adult correctional center. That creates an extremely high risk of exposing that child to violence and trauma, inculcating them into a gang culture, and creating an adult criminal. So absolutely, UNICEF would, in line with the CRC, encourage the government to ensure that all children under the age of 18 are kept separate from adult offenders. And where necessary, that might be having a separate unit or section where children charged with the more serious crimes are properly classified and separated from younger children who are committing lesser crimes, who are also in juvenile correctional centers. And whether that's a specially designated juvenile facility or a separate unit or section of an adult facility, children should at all times be separated from that negative influence of adult detainees.
Good. Thank you. You wanted? Sure.
I just want to ask, under the correctional services, you said that there has been improvement in the service and support. Are there any areas of concern that requires priority in terms of attention? That's the first question. And the second question, those who would have been rehabilitated and has returned to the communities, has there been any sense of assessment in a change in behavior having gone through the level of rehabilitation?
So in terms of Department of Correctional Services, I think a key area which is a challenge in many countries is improving investment in social workers, case workers who are working within correctional facilities, because they're really the key to assessing individual children and helping them to address their risk factors and turn their lives around. So we often focus a lot on the security, the fencing, the physical infrastructure, the fencing, and the prison guards. But in fact, what we need is more investment in social workers, psychologists, and educators who can work constructively with those young people while they're on the inside, so that they're better prepared for release. The other key gap is ensuring seamless support from the juvenile correctional centers back to the community, and making sure that children who are released get the support that they need back in their family to reintegrate successfully. Because that harsh, the doors open and you're out back to your community can be very stark for a lot of young people. So having that, those wraparound services available to receive the child back and continue the support and assistance and the supervision to make sure that child stays on the right track is really important. There isn't, that I'm aware of, unfortunately, any evidence in Jamaica in terms of the success of reintegration of children who've been released from imprisonment. There's a lot of evidence globally to show that those two elements, appropriate support while they're in the institution and then effective assistance after their release, has fairly high levels of support, including for high risk of violent juvenile offenders. The key is working with, when the child returns, working holistically with the child and their family, kind of wraparound services that reintegrate them with family and positive social peer networks, put them back into school, vocational training, or find them a job, and help them to become, to find their place in society. Restorative justice components as well that work at healing, that support the young offender to provide the young offender with the opportunity to make amends to the person who was harmed by their actions, to their own family, and through a restorative justice process promote that healing. Also helps ensure successful reintegration.
You're not saying to us that there ought not to be any period of sentencing. What you have said to us is that it is left to the judge's discretion to exhibit and demonstrate some level of flexibility depending on the unique circumstances in relation to the act. In your estimation and maybe data, what would be an average if we were to place ourselves in making a determination outside of what we have called for the minimum of 20 years? What would be an average based on data that you would have studied?
Currently, under the law, you've already got life imprisonment. So we've already got a child who's subject to a term of life imprisonment. The only question really is whether we further stipulate how long they have to serve before they can be released. And there is really, as I said, there is no really average, because there's no average murder and there's no average child. Each child, and the reason they got there, the risk that they pose is unique. So the approach is we have that life imprisonment already there. The child is under that sentence of life imprisonment, and then we allow judges, based on their years of experience and discretion, to determine in an individual case, based on all of the factors they're able to weigh, what's most appropriate for that individual child, without trying to mandate a one-size-fits-all sentence that may not be appropriate in the individual case.
I think the DPP wanted to ask a question.
Last comment.
Sorry,
just one. But what we have to have some clarity about is that if we introduce a mandatory sentencing minimum of 20 years, we're not talking about a child coming out at all. There's no possible circumstance where the person who went in can come out still a child and open to all those things that you're speaking about. It's an old person who is coming out with probably no attachment to family, no capacity to be employed, a very dysfunctional human being who now might be more of a threat to society than the child who went in.
DPP, you wanted to ask a question or a comment?
Good morning, everybody. If we could be permitted to make a comment. I'm not going to say as usual, but it would appear, and understandably so, that the discussion is very accused specific. Certainly on this side, we have had to deal with child offenders who, I dealt with one a couple of years ago or last year, where at the age of 13, he lured his neighbor, who was a 50-pound, 9-year-old, into the bushes and buggered her, raped her, and strangled her. And it was her father and the community who came upon the body. Now, when I prosecuted him, he was 17. And when one looked at the child psychologist report and the social worker's report, he was totally without any regret or remorse. Now, he received, I think, between 23 and 25 years after being found guilty on all 3 counts. Now, as a matter of law, he would have really been liable to be charged for capital murder. Now, we know, as a matter of law, that he couldn't be sentenced to death. But the circumstances, it was a 3-count indictment, would be within one of the categories falling under murder in the course or furtherance of rape or some other category. We go to the other end of the spectrum, where when you see children in conflict of the law, with the law, it will also be in domestic situations where one stabs the other at school or they stab another family member at home. Now, what we would be proposing as a chambers, looking at the proposed amendment, is that perhaps the mandatory minimum in respect of 20 years be left for children who have committed murder in the course or furtherance of one of the categories, which would make them eligible to be tried for capital murder. And we would suggest, to meet the concerns just expressed, and maybe for some of the legislatures, that all other types of murders, the judge be left with the discretion, depending on the circumstances, depending on their antecedents, depending on what the child psychologist says, and depending on everything, to impose a sentence as they deem appropriate. I say this because certainly in the recent case of Tafari Morrison from the Privy Council, and we benefited from an excellent opinion on this area from Ms. Kathy Pike, one of our senior deputies, where she said, and I quote, "Tafari Morrison is instructive, that is where a 16-year-old, the sentence in terms of the mandatory minimum was upheld. That's of 15 years. It is instructive in respect of the constitutionality of the imposition of a mandatory minimum sentence upon a child. In Morrison, the appellant appeals the dismissal of his appeal by the Court of Appeal in Jamaica against the imposition of the minimum sentence of 15 years on the wounding with a firearm count on the basis that the sentence was prohibited by the Charter of Fundamental Rights and Freedoms." And I am sure that, as the Minister had said publicly, and I note that there are several attorneys, members of the House here, that it is quite clear that, well, it was said that the court was satisfied that the minimum sentence imposed in this case was not incompatible with our charter, but accepts that considering the wide operation of the provision to children, there may be cases where the minimum sentence would constitute inhuman or degrading punishment or treatment. That does not, however, require the board to strike down that portion of Section 20. So it would seem that the proposal for minimum mandatory in this case would pass the test of constitutionality, but it is our view that a distinction should be made between the various types of murders in respect of where this mandatory minimum would obtain. And it is quite clear, and one understands. You know, ladies and gentlemen, as a prosecutor, we have to have a split screen when we assess matters. There is the half that can understand the concerns raised by the last speakers and perhaps by my learned friend, the children advocate, who was a former prosecutor. So she would understand the split screen approach. Dare I say that my learned friends on the other side for the defense, Senator Scott Motley and Senator Fraser Binns, and perhaps the learned President of the Senate, and of course the chairman, may not necessarily understand as much as we do, because we're in the trenches every day about the split screen. So we have the concern. But on the other side, there is the debt to the community. I have heard you. But if you saw the entire community, the father, the mother, the family who were totally traumatized by what that 13-year-old did to that 50-pound 9-year-old child. If you saw the pictures, and I had to handle it to show it to the jury, of the child's tights, her underwear that were taken, found at her ankle, and how she was spread-eagled, you cannot tell the community that you are going to elevate the rights of the child offender and ignore their debt to the community and the society. And one would not want to see a situation where, if we go too far over to what you are saying, what you would be consigning the child offender to is a feeling of entitlement, a lack of accountability to the community. This was a next-door neighbor who, even when the alarm was sounded that the child was missing, he was there, he said nothing. And it was the quick action of the police, after the community realized that he was responsible, that took him out of the community and carried him to the police station that night. Otherwise, he may have been the victim of jungle justice. So the very unique position of a legislator, and I wouldn't want to be in your position necessarily, not now,
I think you can see the challenge legislators have.
Because
trying to balance both sides.
But you don't have our split screen, because we have to objectively indict that child, because that is the right thing to do. But then the judge would have a child psychologist report, the judge would have the SCR, social inquiry report, the police antecedent, and the child would have the views of the community. And we also have a victim impact statement. But we believe that it would be appropriate to have the minimum mandatory for murder committed by a child in respect of the capital murder categories.
Thank you, DPP.
Yes.
You wanted Senator Sapir?
Most definitely, Chair. You wanted to respond to the DPP? No? Okay. Thank you. Thank you, Chairman, and good morning. I took my time to listen to all input. Thank you for your contribution. Could I get it clear? You are a child psychiatrist?
No, my background actually is, I'm a lawyer. My background is as a criminal prosecutor from Canada.
Child justice?
Yes.
Yes, okay. All right, so I'm looking through this through the lens of being a psychiatrist myself, yes? And, you know, Chairman, I have sat on quite a few joint selects, and there's a permeating issue that I have where the health care of our people sometimes is not considered at the level that it should. And what we're discussing here brings very much to the fore that issue. When a child commits murder, invariably, most of the times, there are two victims. That child who perpetuates murder is likely to have been a victim of abuse, of trauma themselves, what we call the adverse childhood experiences. And in my capacity, I make effort when I'm teaching medical students and psychiatry residents to implore upon them that before you make a diagnosis of conduct disorder or oppositional defiant disorder or any other neurodevelopmental disorder, that you put first the disorder of child abuse or PTSD that has resulted in that child exhibiting those behaviors. So when a child commits murder, there is the victim that unfortunately has suffered the consequences at the hand of another victim. And the challenge is that we must, in government, seek to find the balance between justice and rehabilitation. We have to find a sense of justice for the persons who have lost their loved one in very heinous ways, oftentimes, unfortunately. And DPP, I fully understand and appreciate what you must go through on a daily basis, especially when dealing with these cases. But we must disaggregate it. The issue of health and mental health, what we're speaking of here is the subspecialty of forensic psychiatry. And this is woefully needed. In the entire Caribbean, there is one forensic psychiatrist who is here in Jamaica, Dr. Clayton Sewell. And the issue that we have is that a lot of the cases that we discuss in this criminal light, and let me explain that forensic psychiatry is where healthcare and the law interacts. So anytime there is any medical situation that may impact on the law or vice versa, a forensic psychiatrist is the specialist who comes in to see to it. And what we have been trying to relate in terms of the administration of justice, there needs to be a forensic psychiatrist facility that sees to the offenders who are diagnosed and determined to have an underlying issue that affected their performance of whatever crime. This goes for children and adults. So in terms of what was indicated before, the concern in terms of whether or not the rehabilitation is effective, whether or not mandatory sentences will be effective, we must send a signal for justice, yes. But at what cost? Because we have heard that it doesn't work sometimes. At times there are repercussions from that person who has served the time and come out with vengeance in their heart because they themselves were victims. So I'm a strong advocate for a case-by-case analysis, but yes, for certain crimes that you have done the necessary prerequisite to determine that that child or that perpetrator of a heinous murder themselves are not victims who inherently may have a sociopathic or antisocial personality that is developing, that they themselves are going to be deemed almost irredeemable, that they have committed that heinous act, yes, there should be a minimum sentence that drives home. But for that, a message, but for that to be enacted, we must see to the provision that every other child, likely themselves, has been a victim of a crime, and they in turn are basically living that out. So I just repeat repeat that when a child commits murder or those serious offenses, it is significantly related that they themselves are a victim of one of the adverse childhood experiences, and what they are manifesting is the consequences of that. Thank you, Chair.
Thank you very much, Senator Longmore. I want to thank UNICEF for really an excellent presentation, and also for the time you took to put these documents together. I've had a chance to peruse them, and really, it's clear you did a good amount of work. And I want to thank you, and I can assure you that your presentations today, you can see the reaction, and also, you know, the documents you submitted, that they will assist in influencing us as to the way we go. So please, you can remain if you want, okay, to hear the other two presentations, but it's up to you. Thanks again. We'll now have the President of the Bar Association, Mr. Alexander Williams. Mike, if it is working. No, just check. Apparently.
Hello? Yes. So, thank you, Mr. Chairman and members of this Joint Select Committee for this opportunity for the Bar to express its comments on the bills to be amended. If I might, Mr. Chairman, just begin at paragraph 36. I think I'm going to begin at paragraph 36 of our submissions to say essentially what we feel. So the Bar Association suggests that in terms of a policy directive, especially for children and youth, that the intended mandatory minimum sentences be limited to repeat offenders only if implemented at all. The JBA maintains, however, that it should not be implemented at all. And if you don't mind me drawing on comments made so far in this hearing, member Sophia Longmore spoke about a case-by-case analysis, and I think she also expressed a support for a mandatory minimum. And I hope I'm not misunderstanding for certain cases. And I hear Madam DPP speak about what goes into a trial judge's determination of an appropriate sentence and the different factors that are taken into account. And it seems to me, at the end of the day, where we all seem to be saying the same thing, that there needs to be an opportunity given at a trial stage, i.e. the judge, to deal with the circumstances of a particular case in coming up with a sentence. And the fact is, if we come to that position, then it's actually antithetical to a mandatory minimum. Same way in which trial judges has a discretion to impose a minimum, a trial judge has a discretion to impose a maximum within the sentencing guidelines. And if I might just use my own words here, these are my own words. The judge who has to sentence a monster that happens to be a child, right, can impose the maximum allowable in the same way that that judge is dealing with a monster that happens to be an adult. So now, if we consider that and consider all the heinous positions that can take place, should we have what seems to be the proposal, legislation that imposes mandatory minimums in all cases? All right? So, having said that, we recognize the growing crime rate in Jamaica has led to passing of several statutes. And I pause here to make the point that we now have a statutory provision allowing for the prosecution to seek a more appropriate sentence in instances where they feel that it is too lenient. So we are approaching these bills against the background of the fact that the prosecution now has that right. And we are also approaching these amendments against all that the DPP has just said, what goes into a trial judge coming up with a decision as to what is the appropriate sentence. Social inquiry report, victim impact assessments that can be done, etc., all of that. You weigh up aggravating circumstances as well as mitigating circumstances. The case that learned friend the DPP referred to also made mention of the fact of Section 42 of the Criminal Justice Amendment Act, which sets out a whole regime of mitigating circumstances when an accused pleads guilty, which would be applicable to a child that pleads guilty in certain circumstances. So, once again, I'm making the point that we are approaching these amendments against all that legislative background and ask ourselves if we really want to impose mandatory minimums across the board for children. So, these sentences are set by Parliament and remove discretion from judges, forcing them to impose a specific minimum sentence regardless of the circumstances of the case or the individual offender's background. The association maintains that judicial discretion is an essential feature of a fair justice system. It ensures individual justice for each case and each circumstance. Mandatory minimum sentences passed by Parliament have no regard for judicial discretion. The objectives of sentencing a person are denunciation, deterrence, separation of offenders from society, rehabilitation of offenders, and acknowledgement of and reparations for the harm they have done. We acknowledge that long periods of confinement would be the most effective method to neutralize dangerous offenders and to deter defendants or others from committing serious offenses. We are equally aware that shorter sentences may unduly depreciate the seriousness of the crime in the eyes of the society. However, mandatory minimum sentencing is unable to consider the individual rehabilitation needs of offenders. Instead, it inhibits or denies judicial discretion and will produce results counter to the rehabilitation of an offender. So, a minimum sentence may not be appropriate in all cases and will not carefully consider all the peculiarities of each matter, each offender, and each victim. Post-traumatic stress disorder, other mental concerns. I refer to the principles of sentencing by Arthur D.A. Thomas. Youth is one of the most important mitigating factors, and that the young offender is usually treated less severely than an older man in similar circumstances. We refer to Richard Edney and Mirko Bagarich in the Australian sentencing. That's another text. The authorities disclose that when considered as a mitigating factor, youth will generally be given significant weight. In particular, it will compel the parsimonious use of criminal sanctions, which do not have the primary aim of rehabilitation. The underlying justification for such a policy position is the idea that the immaturity of a youthful offender may lead to such offenders not being able to appreciate the extent and nature of criminality involved in their conduct.
All right, Mr. Williams, if you would just highlight, I think we have the script.
Very well.
So if you just highlight
just to
the
say,
main points.
and just to say, and I'm glad for that intervention, Mr. Chairman, because quite frankly, I didn't really want to read it. Just to say that, in a nutshell, putting the constitutionality issue aside, of course, a mandatory minimum sentence is not necessarily unconstitutional. Once you avoid sections 13.3K and 13.3O in the Charter of Rights, dealing with child protection in one instance and cruel and inhuman treatment in the other instance, right? So we're not necessarily arguing that it is unconstitutional. We need to be mindful, though, about our treaties, our treaty obligations, and the danger of going to the extent of unconstitutionality and the requirement in our treaty obligations to ensure that we treat children in a special way. So the children's advocate is here. I don't have to put any powder in our weapon, pardon the analogy there. But in relation to one particular bit of legislation, it is actually called the Child Care and Protection Act. That's what the act is called. That in itself speaks to the policy directive, and I don't mind saying, our treaty requirements, that we must treat children specially and carefully. So we have to be very, very cautious when we get into the area of mandatory minimum sentences for children whose growth, mental growth, may be not up to the particular standard to accept the nature and consequences of their acts, especially where they're operating with social and psychological deficits. If this Parliament is to consider mandatory minimum sentences, we're of the view, as expressed here, restricted to repeat offenders. Now, I've just heard what the DPP has said. And
when you say repeat offenders,
meaning that
you're not talking about killers. You're talking about repeat other criminal offenses. No, but I would hate to think that you have repeat killers coming before the courts. I mean, who have been convicted and coming again. In other words, my hope is that you are not saying that the person has been convicted for murder, spent 15 years, and now he's out again committing murder. Those are the persons to whom mandatory minimum should be imposed. Try again.
Yes, Mr. Chairman. So I suspect that that comment may not fit so nicely into murder, all right? Killers, as you have mentioned. Although the DPP may be willing to disclose that you do have repeat child killers that they have to deal with. So I was going to make the point, Mr. Chairman, that I can see where a mandatory minimum sentence, even in a situation where you're dealing with a child, could perhaps be appropriate where the child has committed one offense in a situation where another heinous offense has also been committed. In other words, where the circumstances are at a particular end of the continuum, where you feel that you want to, how do I put it, limit the discretion of a trial judge to a particular minimum. Don't ask Mr. Chairman what that minimum is, because I don't know.
Well, I would be very happy to hear from you as head of the Bar Association what you would consider an appropriate mandatory minimum in some of the circumstances. Bear in mind, we're adjusting not only for child offenders, but in relation to capital murders and also in relation to non-capital murders. If we go back, President Williams, 40 years ago, the death penalty was the penalty, was the punishment. And for child offenders, it was the governor serving life sentence in a way at the Governor General's pleasure. So the child offender would be at the mercy of the Governor General before he or she would be released. So since then, regrettably, with the 1992 adjustment of sentencing for capital murders, non-capital murders, which was in the early 90s, 1992, I think. Sadly, the incidents of murders have really got out of hand. And that is what the legislature is cognizant of. That since we have reduced, or should I say, removed the death penalty in a way to the most serious offenses and split murder into capital and non-capital and providing discretionary sentences to the judges, which they have used well in most cases. The problem is that the society is calling on the legislature. Many, including members of your association, are now calling back for the death penalty, which, you know, is still on the books. So the question we ask, and would like your assistance, President Williams, we, the legislature, or the government is proposing to the legislature certain figures in terms of mandatory minimum to deal with capital and non-capital, because we are trying as best as possible to reflect the demands and how we balance the rights of the accused, the hope and expectations of the family of the accused, but at the same time, with the reality that the society is fed up with murders, fed up with persons who feel that they can take a chance. And the victims and their families feel that justice is not done, because when a person has committed a serious offense and get 10 years, 20 years, and would be back out in the society after 15 or 20 years, to face them again, because it's a small society. They feel that the legislature and the society are not protecting them. So the question to you, President Williams, balancing as a minister, as a justice point, what would you consider to be an appropriate minimum mandatory for capital murder, where, as you know, it could be life imprisonment without parole? Should there be a high minimum mandatory? We have proposed 50 years. Non-capital murder, where it could be life imprisonment or fixed term, we have proposed that at least somewhere in the region of 30, 40 years. We are talking about adult offenders. No, I mean, with respect to the child offender, we are saying it's 20 years. But at the same time, don't ignore that if any of these offenders are determined, or should I say, have the option of pleading guilty, they can negotiate with the prosecution under the Plea Bargaining Agreement and Negotiation Act, and an appropriate sentence can be recommended to the judge. So bear in mind, these particular legislation amendments are not excluding the Plea Agreement Negotiation and Agreement Act. So in appropriate cases, in fact in all cases, they could plead guilty and at the mercy of the prosecution and the judge, a lesser sentence can be imposed. And in fact, they can indeed negotiate before the plea of guilty so that an appropriate sentence can be recommended to the judge. That is not to say that in serious cases like capital murder, that the sentence may well not be life imprisonment without parole, even if they plead guilty. You see, so basically what one is saying though, there are many appropriate cases where it may be spur of the moment murder, it may be one involving children, that the plea negotiations and agreement act could take it out of the minimum mandatory with an appropriate sentence being discussed between the defense and the prosecution for the judge to make a final determination. Okay? So, having said that, President Williams, your comments.
I know, Mr. Chairman, you're doing your best to help me to come up with a figure. I can't come up with a figure. When you prescribe a mandatory minimum of 50 years, what would be the maximum that a judge could impose in a situation where the mandatory minimum is 50 years? And the same question would be asked for a child 20 years, and so on. Again, you know, where I began, where we all accepted that there must be some discretion in a judge to come up with an appropriate sentence, even in a context of a minimum. There should still be that discretion. So, having said that, the most I can offer, Mr. Chairman, is impose a mandatory minimum in exceptional circumstances, especially for children. That mandatory minimum should be geared towards deterrence, that principle of sentencing, and separation of offenders from society. I suspect when you're dealing with a mandatory minimum situation, rehabilitation would be a small consideration. I am hoping that that will be the situation. So if rehabilitation is a small consideration and you're dealing with deterrence and protecting society, right? Impose a mandatory minimum in those special circumstances.
Thank you, Mr. Chairman. And it's not quite a question to Mr. Williams. I was going to say Senator Williams. But it's more of a comment. And I want to give you my full support in terms of the challenge that we face in determining or suggesting a mandatory minimum. Because the question asked by the chairman could also ask to him, what is the magic of 50 years or 20 years? And I think that, Chairman, the information that we had requested at the last meeting have been circulated and provide some guidance, because when I look at it and I see the sentencing period that have been given, starting from 1991, it ranges from 12 years, and these are all murder, I believe, yes. So you have 12 years for a 1991 case where there's a murder with knife. Then you have another one where the person was sentenced and eligible for life and eligible for parole after 40 years. Then it goes on to another one, murder with a firearm for 30 years, eligible for parole after 30 years and 35 years. And we go up to 2013, there's 22 years, 25 years, and it continues, but it makes good reading, because what it does, we have another here for 38 years, and that matter was in 2012. And there's a particular recent case that I saw where it went, I think, to 35 years. And the reason for me referencing these determinations, because it provides proof as well as support to the view that the judges really have discretion and they should be allowed to use that discretion because each case will turn on its own facts, and we have to give consideration to the particular facts as unearthed in the trial. I believe, though, Mr. Chairman, that one of the things, and you spoke about giving comfort to the victims. Admittedly, I'm not at the criminal bar at all, but I think that one of the things that would give some comfort to the victims, in addition to the sentencing, is the certainty that the offender will be caught and brought to justice swiftly. There is no doubt that there is a feeling that there is a delay in offenders being caught and offenders being brought before the court and being tried in a timely manner. I believe that if we are going to give some comfort to the victims, then these are some of the things that we may need to look at in addition to the sentencing. And if there is an agreement for a minimum sentence, then certainly that is something that we can look at. But we can't look at minimum sentence in and by themselves. But certainly there are other aspects that have to be looked at and dealt with in a serious way if we're supposed to give the kind of comfort that you mentioned, Chairman. So I wanted to just raise those 2 points because I am in full support of the position raised by UNICEF and certainly by Mr. Williams in terms of not prescribing a minimum sentence, because there is sufficient evidence that shows that the trial judge has discretion when it comes on to sentencing. And that's my contribution, Chair.
If I might just add, Mr. Chairman, this comes from the Morrison decision. This is paragraph 15, and where they're referring to the UN Committee on the Rights of the Child, a general comment, which I understand is number 24 of 2019, stating that mandatory minimum sentences were incompatible with the child justice principle of proportionality and with the requirement that detention was to be a measure of last resort and for the shortest appropriate period. Shortest appropriate period. No, it doesn't mean unconstitutional.
If I may, Minister.
Yes,
If I may.
Yes.
And I say it with the greatest of respect. Dare I say to my dear friend, Senator Sophia, whose smile is much better than mine.
It's a competition of smiles, no?
Not at all. We don't compete. But may I say, I would think that in respect of being in the trenches and being on the receiving end of what relatives of victims want, I pray that you never have to hear a lot of what we have to hear. Yes, they usually are happy when the matter comes to trial, but they are most concerned once the matter is tried in respect of what the sentence is going to be. And the issue for the average victim's relatives is not that the judge has a discretion, but it's whether the bench is being a little bit too conservative and not necessarily giving sufficient validity to the concerns of the community and to the victims. In this particular arena here, it is very, very easy for all of your goodly selves to be very preoccupied with the accused. But as I say, if you do a count here, perhaps it's only the three of us and maybe the children's advocate, because she was a former prosecutor, who knows what it is to interface with the victims and the relatives. So they are very, very, very concerned about the sentencing. And what happened in Kwesi Hart Kwesi Hart, senators, was the case where the young 14-year-old JC boy was set upon by Mr. Hart in the bus, in his school uniform. His bag, school bag, was taken away from him, and he was stabbed because Kwesi refused to give up the watch. And after the Court of Appeal reduced the sentence from 31 years, Kwesi Hart had pleaded guilty. And there was a cry. We had to meet with the grandfather, the father, the stepmother, the step-grandmother. And as tough as we are, it almost moved you to tears. Yes, the hard-bitten DPP is admitting that I'm human after all. But although we tried to explain the range of sentences, the law, as far as they were concerned, they were not interested. And we really couldn't tell them why it was that the Court of Appeal reduced that sentence. So yes, the judges have the discretion. Yes, we do have the right of appeal if the sentence is unduly lenient. But what a lot of the members of the public are concerned is that the pendulum sometimes is going too far away from them in terms of the validation of the concern that the accused is not being held sufficiently to account for what he has done. So it's not just about discretion. So as I said, we believe that for capital murder, and let me remind you of some of the categories of capital murder, where perhaps the mandatory minimum for children would be appropriate, but not where you have other non-capital murder. You have the category where a judicial officer, or God forbid, a prosecutor, or a member of the Attorney General's chambers, or a police officer is killed. That is one category where you could be indicted for capital murder. Where you have murder committed in the course or furtherance of robbery or rape, you could be indicted. Where you have a contract murder, you could be indicted for capital murder. So that is the murder where on the books it would attract the death penalty. Now, children cannot have the death penalty being pronounced against them, which is why we are saying to meet the justice of the situation, the mandatory minimum would be best set for that. And in the case that I prosecuted, the judge who really agonized over the sentence recognized that he could not go below 20 years. And I think he settled after doing the calculations at about 23, between 23 and 24.
All right. Senator Scott Motley wanted to ask. Okay.
Thanks for that, Ms.
From the
Lernin.
trenches.
From the view from the trenches. But I wonder, there are some countries that have mandatory minimum sentences. And I wonder if, in your experience, and if you perhaps can tell us today, if you can, to just help us to understand how utilizing mandatory minimum sentence has helped with their crime problem, particularly murder. I'm not sure if you're in a position.
Well, if I may say, I think you're looking at it perhaps from the pure view of a legislator. We are looking at it not only as prosecutors, but having to interact with members of a community. A sentence, I mean, it has been judicially decided, sentencing is not just for punishment, or it's not just for rehabilitation. The case law says it is to cover punishment, deterrence, and retribution, and rehabilitation. Those are the four tenets of sentencing. So it is not necessarily to help with the crime problem. What it is, as far as the average person in the community feels is for the accused to be accountable, to pay his debt to the community and the society. Well, if it trickles down in such a way and assists in respect of the crime problem, that's a plus. I remember a few years ago, there was a problem where you were having a lot of acid attacks, about maybe 20 years ago. And I remember it's as if all the judges decided that if a complainant comes in here as a victim of an acid attack, the sentences were going to be high, very high. And after a while, it went down to almost nothing. Hardly, anyway, we hardly have acid attacks, again, in terms of the offenses of causing grievous bodily harm with intent, inflicting or assault or be harm. So I don't know if it is correct necessarily to think of it as helping with the crime problem. It is really seeking to make sure that the concerns of the community in terms of how the justice system deals with the sentencing, that it satisfies the ends of justice and their concerns.
Thank you, DPP. Senator Scott Mott, you wanted to...
You know where to find me.
Thank you, DPP.
Yes, Senator.
I don't want anybody to ever feel that we as legislators don't think about the victim. I was saying, DPP, I was thanking you, and I was also saying that I would never want anybody to feel that as legislators we don't care about the victim. I don't know many people who have any kinds of positions of authority, or whether in the parliament or in a community, who are not impacted by the victims and the pain and the hurt. We ourselves, there are some that hurt more than some. And I can count how many, as in Danielle, who had her throat slashed, how much it impacts all of us. It just, for some reason, there are some that you can't forget. You walk around with it for weeks. And I understand why, because you're interacting with the victims and their family with a sort of intensity which you must do, that your emphasis is on the victim feeling as though justice has been done. I beg to submit that there is no sentence which can really make a victim, someone who has lost their family member, especially in those circumstances, that would make them feel that justice has been done. And the truth of it is that when we sit here, as emotional as we might feel, we really have to consider everyone who is impacted. We have to balance it. Now, our formula can perhaps, I find sitting here, be a bit imprecise. Why 20 years? Why 50 years? The judges have some guidelines that they have to adhere to. We don't have that sort of look at this, but look at that. I am not in support of mandatory sentencing, as you know. But when I look at this profile which has been prepared for us as to the sentences, some of them are rather hefty. Some of them, in fact, would be almost in line with what you're proposing. Not you, with what is being proposed. And I think what it does is it supports the argument that the judges do exercise their discretion. What we cannot do is legislate for the exception. We cannot legislate for those that really offend the spirit, in the sense that we can't impose a mandatory sentencing for all murders, because 10 of them, we know they are monsters. You understand what I mean? And I think that is where my caution arises. So if there are 10 really ugly, obviously sick, and disturb persons, such as the example you gave me, am I then to impose a sentence for a young man who gets up, is tired of seeing his mother abused, and kills his father? Because what I'm doing is re-victimizing a victim. He's a victim too. I think that legislators have to bring balance. They have to listen to the voices which are being raised. They have to listen to the people, but leadership requires that you must also lead the people to an understanding of why balance and a certain approach is necessary. So my caution is, Minister, that we must be careful how we proceed down this line, to give a reaction to those who are calling without recognizing that as legislators, we are placed in an extraordinary position, and it is our duty to balance the calls.
Thank you, Senator Motley. Now, you know, Mr. Williams, you're finished, right? You have, okay.
Take it as read. Take the
okay,
presentation.
wonderful. Thanks again for your presentation.
Chairman, I have a comment.
Sure.
Yes, thank you. To be clear, Mr. Williams, your comments are specifically with respect to mandatory sentences for children. Were you also including adults? Because I'm taking it that the context in which you're speaking was with respect to children because of the presentation from UNICEF also.
It includes adults as well. Mm-hmm. My presentation is all-encompassing.
All-encompassing. I just wanted to be clear on that.
And just to say, though, that as previous presenters have indicated, we must tread very carefully when we are dealing with children.
Yes, and that's why I sought the clarification. And DPP, might I say that there is a trench that is even possibly deeper than yours. And that is a trench of the persons such as myself, who the jurors and the judges seek guidance from in our psychiatric and psychological reports based on not just the victim, but the perpetrators. So if we're not in the same trench, we have a trench that is beneath there that we have to deal with such realities. And that is why I emphasize, and I hear Senator Scott Motley, in terms of the balance that is required. There is, I think, a requirement for us to consider the children's case versus the adult case. A child is entitled by our Constitution for care and protection. Let us not err on the side where we are causing more damage where there should be remedy. Let us not seek, we have a tendency to see discipline as being punitive. Discipline is supposed to be positive, you know. Discipline is supposed to be enabling and enhancing the better development, but it requires some amount of restriction for that development. So, you know, I wanted to just make sure that we recognize that I think that we should be tailoring our dispensation for children versus adults in very specific ways. And for children, as I am focusing on this presentation here now, it should be case by case. We cannot have a carte blanche approach to our children who develop in different ways. And let me just indicate this to you, that in terms of, and this is with Daniel Rowe, and a consequence that has come to my attention. We heard it, actually, it was an interview by someone who interacted with her classmates. And one of them commented that the level of anger that that primary school child was feeling, they wanted to kill. Now, a child like that who may go out and in a moment lose control, and the hurt and the anger that we as a society feel around Daniel, that child manifests in a moment of anger, does that child deserve a mandatory sentence? Thank you.
Go ahead. 1 second, DPP.
DPP, just a clarification on the submission.
Well, I was going to, the DPP has not yet presented, but go ahead.
No, just asking, are these...
The document submitted.
The document is called Murder Sentencing Table, 1993 to 2023. Are these examples of children, or these are just murder?
These are examples of adults. We do have some cases, I think maybe about 4 or 5, fairly recent ones involving children. I know that because we had to consult it when I did that case last year. And I would say I didn't see anything more than 15 years. More than 15 years in terms of these were murders in a domestic situation. But as I indicated, we didn't have any where you had murder in the course or furtherance of rape or something like that. But these are all adults, and you see going over time, the years, what we have been seeing. My learned colleague was just saying to me that one of the reasons why we were recommending that Section 42F, where life imprisonment was 30 years, that it has to be amended and be changed, is because we have been having sentences now where life imprisonment and parole not before 35 years. So the parole period is being given, and it's more than what the life imprisonment is. So that is why it would have to go up to 40. We must confess that we have not submitted. We do have submissions, and I undertake that perhaps by the end of the week or early next week, we will send our submissions in relation to both the Child Care Protection Act, which I've indicated what our stance would be, and in respect of the Offence Against the Person Act amendment.
DPP, we're going to do better than that. We like your presentation, what has come so far. And
well, this is just a table, but we can put...
No, what we're thinking is that we wouldn't have more than another 15 minutes or so before we have to stop. So I'm going to recommend members that we adjourned, and then DPP, we return. I think the date being looked at is July the 11th. July, that's 3 weeks' time. The 18th? What happened to the 11th? All right, well, okay. July the 18th, which would give more of our members time to be here. So your presentation will be not only to us, yes, but you know, we hope other members will make themselves available. And we take you first on the 18th at 10 o'clock. So,
you just reminded me that both Senator Brown and Senator Gale asked me to apologize to our guests for their absence.
Yes.
So,
because they had to.
I don't want to get myself in any trouble because they did ask me.
No, right. So I'm going to suggest the DPP that would allow you to send in the submission.
The written submissions.
Right.
And may I apologize in advance. The reason why so many of us came is because very often we are in court.
No, but
so you will not see Ms. Thompson and Mrs. Millwood more. They'll be in court. You may see Mr. Taylor, you may see me. You will see one of us.
We leave it up to you who you bring along with you. So I want to thank the members of the committee and the presenters this morning, the technical team, children's advocate who have come this morning. But if you notice, the Speaker of the House has been waiting she wants to start a standing orders committee meeting.
Okay.
And I must admit I wasn't aware that we had limited time. So want to thank, I think we had some excellent discussion this morning, and UNICEF and the Jamaica Bar Association, you can always join us or view when we return on the 18th to see how we continue. So thanks everyone, and have a motion for adjournment, please. So moved. Wonderful.
Come here. You didn't know it's a driving instructor's party before them can do them thing? Yep, a time for serious business. Under the new Road Traffic Act, only registered driving instructors or institutions are allowed to give driving lessons for a fee. So, make sure you're registered by January 2024 if you want to work as a driving instructor or operate a driving school. Do the right thing. Get certified if you want to teach persons to drive. Let's do all we can to ensure we arrive alive.
Every Jamaican has the right to know what is happening in Parliament, to know when new laws are being passed, and to give their opinions on legislation before either house.
Every Jamaican has the right to see their representatives in action, making laws, holding the executive to account, representing the people, working for the benefit of all Jamaicans.
It is your right to observe first-hand meetings of the Senate, meetings of the House of Representatives, and the meetings of parliamentary committees. You may also take a tour of your parliament.
To find out more about the Houses of Parliament, please call 876-922-0200, follow us on Instagram and Facebook, or visit our website at www.japarliament.gov.jm.
Nutritious food, succulent dishes, superior workmanship, and excellent service. Go, let's grow, eat, and eat. After all, buying Jamaican means building Jamaica.
Jamaica, we are now facing severe drought conditions. Did you know that 12 of 13 parishes received below normal rainfall? 11 parishes experienced meteorological drought conditions in the December-January bi-monthly period. Below normal to near normal rainfall is in the forecast for the island for February to April. Near normal to above normal temperatures are expected for the February to April period. These conditions are affecting the National Water Commission's operations, as more than 260 of the enterprise's 450 systems are supplied by rivers and springs, and these are extremely vulnerable to drought conditions. The island-wide drought is severely impacting the storage levels at the Mona Reservoir and the Hermitage Dam. Other systems in other parishes are also being impacted,